Every bank, insurer, and investment firm in the European Union now runs on technology it does not own and cannot fully control: cloud platforms, payment systems, and software vendors spread across the globe. So what happens when one of those systems fails, or a cyber attack knocks it offline? Since the 17th of January 2025, the EU has one binding answer to that question, and its name is DORA. Let us decode it, in plain English. DORA is short for the Digital Operational Resilience Act. Its formal name is Regulation, EU, 2022/2554, and it is one of the most significant pieces of financial technology law the EU has produced in years. The idea behind it is straightforward. Modern finance depends almost entirely on information and communication technology, usually shortened to ICT, and for a long time the rules governing that dependence were fragmented. Different countries, different regulators, and different parts of the sector each had their own guidance on cybersecurity and system resilience. Some of it overlapped, some of it conflicted, and plenty of gaps sat in between. Before DORA, many of these expectations lived in non-binding supervisory guidance that varied from one country to the next, which made it hard for firms operating across borders to know exactly what good resilience looked like. DORA replaces that patchwork with a single, harmonized rulebook that applies right across the Union. Its goal is to make sure the EU financial sector can withstand, respond to, and recover from ICT disruptions and cyber threats, whether that is a ransomware attack, a botched software update, or a cloud outage. In other words, it is less about preventing every incident, which is impossible, and more about making sure firms keep running, and can recover quickly, when something inevitably goes wrong. DORA sits alongside the broader NIS2 Cybersecurity Directive, but for financial services it takes precedence, because it is the more specific rulebook written for that sector. One reason DORA matters so much is its sheer reach. It applies to around 20 different types of financial entity, a deliberately wide net. That group includes banks, insurers and reinsurers, investment firms, payment and electronic money institutions, crypto asset service providers, trading venues, fund and asset managers, and even credit rating agencies, among others. If an organization is regulated as part of the EU financial system, the starting assumption is that DORA applies to it in some way. And crucially, the regulation does not stop at financial firms themselves. It also reaches the critical ICT third-party providers that serve them, the large cloud services, data platforms, and technology vendors the sector has come to depend on. That extension is one of DORA's most novel features, and we will come back to it shortly. The framework does allow for proportionality, so the exact obligations scale with the size and risk profile of each entity, but the direction is clear. A very wide slice of the market now shares one common standard. At its heart, DORA is built on 5 pillars. Think of them as 5 connected work streams that together add up to operational resilience. The first pillar is ICT risk management. DORA asks firms to maintain a proper governance framework for technology risk, with clear responsibility sitting at board level. The message is that cyber resilience is not only a job for the IT department, it is a leadership accountability, and senior management is expected to understand and own it. The second pillar is ICT-related incident management, classification, and reporting. Firms are expected to detect incidents, classify them consistently against common criteria, and report the major ones to their regulators within set timelines. The aim is a clear, comparable picture of what is going wrong across the sector, rather than each firm quietly handling problems in its own way. Consistent classification also helps supervisors spot patterns that cross borders, rather than seeing each incident in isolation. The third pillar is digital operational resilience testing. Firms need to test their systems regularly to find weaknesses before attackers do. For the most significant entities, that includes an advanced form of testing known as threat-led penetration testing, or TLPT, essentially a controlled, realistic simulated attack, carried out at least once every 3 years. The fourth pillar is ICT third-party risk management. Because so much of finance now runs on outside vendors, DORA sets expectations for the contracts firms sign, requires them to keep a register of information about their providers, and asks them to monitor concentration risk, the danger of leaning too heavily on a small number of large suppliers. The fifth pillar is information sharing. DORA encourages financial entities to share cyber threat intelligence with one another on a voluntary basis, so that a threat spotted by one firm can help the whole sector prepare. It is optional, but the intent is a more collaborative defense across the industry. That fourth pillar leads to one of DORA's boldest ideas. For the first time, certain technology companies, not banks, but the providers sitting behind them, come under direct European oversight. When an ICT third-party provider is designated as critical, because a large part of the financial system depends on it, it falls under a dedicated supervisory framework coordinated by the three European supervisory authorities, the European Banking Authority, the European Securities and Markets Authority, and the European Insurance and Occupational Pensions Authority, better known as the EBA, ESMA, and EIOPA. Each critical provider is assigned a lead overseer, which can examine it, request information, carry out inspections, and issue recommendations about how it manages risk. The logic is simple. If a handful of major cloud platforms effectively underpin the whole European financial system, then a serious problem at one of them is no longer just a private commercial matter, it becomes a question of financial stability, and regulators want proper visibility into it. So where are we on the calendar? DORA was adopted in 2022. It entered into force on the 16th of January 2023, and it has applied since the 17th of January 2025. That 2-year gap between entering into force and applying was the implementation window, time for firms and regulators to prepare, and for the detailed technical standards sitting underneath the regulation to be finalized. The distinction is worth understanding. Entered into force means the law legally exists. Applies from means the obligations are now live and enforceable. And because DORA is a regulation rather than a directive, it is directly applicable in every member state, there is no separate national law needed to translate it into effect. In practice, that means since early 2025, DORA is simply the operating standard for digital resilience across EU financial services. For anyone working in or with that sector, it is not a future project on the horizon, it is the current baseline. So that is the shape of it: 1 regulation, roughly 20 types of entity in scope, 5 pillars of resilience, direct oversight of the biggest technology providers, and a start date that has already passed. The thread running through all of it is a single, practical question: when technology fails, can the financial system keep serving the people who rely on it? If this made DORA clearer, consider subscribing to Compliance Decoded. We turn the regulations shaping finance and technology into plain language, one topic at a time. And tell us in the comments, which of the 5 pillars is the biggest lift for your team? We read every reply, and your questions often become our next explainer. Educational overview only, not legal or compliance advice. Consult a qualified professional for your situation.